Well, thank you. Still on the judge's findings and why we say the judge was right. We've given the court the document of references, but can I, in relation to the efforts taken of Mr. Sousa's view on the new money, take the court to one passage in his written evidence and one in his oral evidence? Can I start in the supplemental bundle, tab 1? I'm so sorry, tab 6, Mr. Sousa's full statement, at page 200. Here at 3.10 is expressly dealing with a complaint by the appellants in relation to the new money. Could I please invite the court just to read 3.10.1, and then we'll see what he said in his oral evidence when challenged on this. So he refers to the challenges the group has found raising the new money. He says that he believes they represent the best terms available to the group, reflecting the investment risk. Says it's the cost the group has to incur to deliver the restructuring because it needs the new money, and in that regard refers to the fact that there's still not been a full subscription even within the plan creditors.
I mean, just the first bit of that. He talks about the commercial negotiations, and he says they represent the best terms available to the group. I mean, does he mean in the negotiations, or, I mean, he's only referring to the terms that have been commercially negotiated. So it's in the negotiations, they are the best terms available, aren't they? But he's not saying, they are comparable to what the group could have obtained in the market post-restructuring. He's just saying they're the best terms available as a result of the commercial negotiation with the new money providers, i.e. the ad hoc group.
In relation to the new money providers, it's not, obviously it's not just the ad hoc group, it's broader than that.
No, it's okay. Well, not just everyone, but they're the ones who've been doing the commercial negotiation. He talks about, you know, the new money has been commercially negotiated, and that's between, as I understand it, primarily the ad hoc group and the company. I mean, that's where the negotiations, that's what justifies the work fee. Yeah. And whoever's getting the work fee. But his comments about the best terms available are in that context. He's not talking about having been out-tested the market or anything else. He's talking about the terms negotiated. It's all one sentence.
Well, we say he's talking about, this is him dealing with where he's got to on pricing the new money after, in the balance of his evidence, explaining the extensive outreach, the problem of filling the new money hole, and all the different places he had to go to fill that new money hole.
That's not what he's talking about here. Here he's talking about he doesn't mention anything else. He talks about they've been commercially negotiated, and the extraordinary challenge the group has faced to secure new investment, which he goes on below, which I think is a much more general account of what was done, which I think we've looked at. And they represent the best terms available to group in that context. I'm not sure he's saying any more than that, is he?
Malo, can we just then look at what he was said when he was asked about this during cross-examination? And
or at least it's unclear to me that if he is, that's what he is saying. There's a lot missing from that sentence.
Because the question put was about the risk attached to the new money. So I think then jumping more on my lord's point.
Yeah.
Does the court have the transcript bundle? It's tab 1 of the transcript bundle, so it's day 1. It's page 43 of the bottom numbers. Page 42 of the internal numbers at the top. And this is where Mr. Thornton asks Mr. Sousa about the debt to start with, beginning at line 7. He says the shares will have no value if the company can't pay its liabilities. On the basis of this plan, any of the debt that comes out of the plan is likely to be recoverable in full, isn't it? Yes. Then asks about the coupon. And does the court see that then, in relation to this new debt, the question is posed, and would you agree that it's low risk debt? So this question is posed in relation to the new debt. Clearly is of lower risk than the equity, because it ranks ahead of the equity. And then Mr. Sousa deals with that carefully in a relatively lengthy exchange that goes to page 46, line 8. Can I, in view of the way the points were put this morning and the court being keen to see the evidence, can I ask indulgence to read this relatively lengthy chunk?
Yep.
To 46, yeah.
My lord, yes, page 46 of the bundle, line 8.
Yes, we've done that. Thanks.
My lord, thank you. So he was asked about the risk and explains the context of the high risks involved in an EPC business. That was the point I was making earlier. There's no hard assets of value in relation to this business. It's all dependent on contracts. And in relation to those contracts, when reaching an assessment of risk, of course, although when carrying out an enterprise value, certain assumptions are made in view of the director's business plan and the expert's professional opinion, if the contract doesn't go well, it's a zero return.
or worse. Or worse.
Yeah, absolutely, or worse. Precisely. Maybe just before we turn to another passage within the evidence and make a point on the judge's findings, could I just show the court as well what Mr. Sousa said in his first statement, which I think is to address my Lord Justice Snowden's point that Sousa 4 may have been focused on only one aspect of the new money rather than more broadly. And that's Supplemental Bundle, tab 1, page 67. So Supplemental tab 1, page 67, underneath the heading Other Money Equity. So this is where Mr. Sousa deals with people other than the planned creditors, so not the ad hoc group. And it's 10.12 that I would kindly ask the court to read, please. So again, the extensive efforts and the pricing being the best that could be achieved.
But that's, but I think, again, it's difficult to tell, but he talks about the challenge to be facing getting funding in from elsewhere and the risk associated with the investment. I mean, that's just talking generically about the company as is.
My Lord, no, this is talking about the amounts at 10.11 that come in under the plan. It's talking about the efforts in securing those amounts that come in if the plan is sanctioned from people other than plan creditors. One only ever gets any new money if one has a plan, because no one will give new money to a company without a plan. I'm
aware of that. That's the point I've been putting to you.
And so that is the context. Because all of the discussions around new money and investment assume the successful implementation of the restructuring, because that's the context against which pricing discussions take place. Because there is no commitment in advance of the effectiveness of the plan.
But he hasn't. If you say this is the challenges we are facing getting funding in from elsewhere and the risk associated with the investment, if you ask us to read that as solely referable to the new money, I mean, where does he actually say, what they did in terms of trying to get the new money in separately from the general discussions, which we saw that Lazards were involved with and everything else? That's really the gap that I think we're struggling, certainly I, for my part anyway, is struggling with. That there just isn't the evidence of what new money to a restructured group would be priced at in the market generally, other than what they've been able to talk to people already involved in the much wider attempts to restructure the group or find a buyer for it or anything else. That's my evidential gap at the moment.
I see that. Well, we saw this morning that the IBR went out to parties who were within the Lazard process, which resulted in some now participating in the new money. So we saw that outreach as well this morning. Yeah. We've also seen outreach to other people, such as the new financial investor and the negotiations with them in relation to the pricing of the new money. That's what's addressed here.
Yeah, but that was all on the basis they were offered new money on the terms that are part of the plan.
Well, no, the new financial...
They weren't asked to quote, they weren't asked to quote, you know, there wasn't a competitive process for quoting. If there was a competitive process for how cheaply can you offer us new money, I haven't seen it.
Well, two things. I think first, we would respectfully suggest we haven't seen a hint of needing that before, certainly not in the cases we looked at earlier, the Virgin Active and the Thames decisions. Secondly, what you do have is extensive evidence that there were negotiations with a wide and disparate group to fill a new money need. And you also have clear evidence of Mr. Sousa in relation to how that pricing was achieved and the risks involved, including in cross-examination. You have the Nuttree letter, who are a new investor, saying they will walk away if the terms are changed. They already think that the new money is not good enough. We looked at that this morning, supplemental bundle 2, tab 37, which the judge also touches on. And then Mr. Reid already gave similar evidence in relation to pricing, and that was the other point I wanted to show my lord was a bit from his cross-examination before I make some more general points about maybe there's a disconnect between what my lord is suggesting to me should be there and what is in fact there.
Before you do that, can I just ask a timing point? We saw earlier about, I think, Lazard's Mr. Sousa going out with the benefit of the IBR, I think in late 2024.
My lord, yes.
The valuation evidence we've seen is March 25, isn't it?
My lord, that's correct.
So is it right that we were seeking interest from people willing to put money into this new venture, new company, without the benefit of the independent expert advice as to what it was worth?
Yes, I mean, that expert advice has been adduced for the purpose of showing the expert's opinion as to the value within the context of these proceedings.
But isn't that advice relevant generally to someone if I wanted to invest in a company, wouldn't I be interested in seeing that advice, and wouldn't that help me in my decision?
Well, the IBR may, and that's why that was provided then again to the Lazard entities. I suppose in relation to the Teneo report, that was done at an earlier date to start with and then updated. And that, of course, was available at the least to all senior secured plan creditors. And my lord has seen that there was not any further uptake.
I don't know what's in the IBR. I don't know what it says about.
Oh, no, I'm so sorry. I was addressing the my lord's question in relation to the availability of the Teneo report.
The valuation report.
Indeed.
Which wasn't available at the time.
No, wasn't available then, but was available from an earlier version from the convening hearing at the latest.
The plan's been, the plan's been formulated by then.
My point was really in terms of the relevance of that document, it is clearly for the purpose of showing an expert's view to the court.
Yeah, but my lord, but unless I misunderstood my lord's point to you, he's saying, look, if you want to get the best deal on new money, you go into the market and you run a competitive process in which you show people in the market what they are going to be investing in. And one of the main documents you would generally show them is a valuation report which shows that they're going to be investing into a company which, accounting for all the various risks that its business has, Teneo think is going to be worth between 1.5 and 1.85 billion US dollars. That's the basis on which you say to people, you know, well, give us your best terms. And that's the process that I'm struggling for myself to identify.
I think the short answer to that is that report was provided for the purpose of the hearings, not at an earlier stage.
Which is, I think, the point my lord is making to you and myself.
It clearly was made available to all the plan creditors within the context of these proceedings, and that has not led to a greater uptake of the new money within the senior secured class.
Right. But with respect, I think that's a different point. I mean, you've got 2 points. One of which is you say, look, the people within the class didn't all take it up. They can't have thought it's great. And that was the very first paragraph you showed us after lunch. That was that. There's a second point, which is this actually, quotes, competitive? Are these competitive rates in the market? And for myself, if the judge was going to say, these are, if you like, I think it's the way you introduced it, these are competitive rates, then you'd expect to see a process akin to the one my lord's put to you, which is that you go out and show how good and bright and shiny you're going to be post restructuring, and you say, so give us some cheap rates to borrow some new money. Now, if what's being given to the plan creditors is no more than the result of such a process, then there's no element of bounty or anything else. It's just a cost. But if it is more, and at least on the face of it, the returns, the numbers we've seen seem to be quite chunky. At least on the face of it, seems to be more than I would expect an entity of this size and value to be able to command in the marketplace, then I don't really understand how it's said to be competitive, unquote. That's the issue.
No, I see that. The risk of repeating, we have an outreach over a lengthy period of time to try and seek M&A offers and investment with Lazard. That led to nothing. We then have an independent business review prepared on the assumption of the restructuring. As Mr. Sousa explained, he went back to people. That led again to nothing. Investors clearly need to form their own assessment of risk when determining whether to invest. The Tenea report is a not for investment document. That's not the purpose for which, of course, it's prepared. We couldn't share that at an earlier stage as we're...
The IBR report was also not for investment purposes. You showed us that this morning.
If we produce something for investment purposes, I think being a listed company, that we have cleansing issues immediately. So we have done the best we can to try and find new money, making announcements along the way in relation to relevant milestones. What the judge did have, and what we again say is important, is Mr. Sousa's view of where they'd reached, CFO at the coalface, knowing the business, particularly the nature of the contracts business, and knowing the risks involved in that business. We have the evidence of, by letter of Nuttree, who did not have any real exposure to the group, coming in and saying in their letter, we saw, if the terms get changed, we walk away. We already think things have got worse since we committed our funding.
Yeah, but all they're saying is we like the terms we've been offered. If you try and shave us down a bit more, we'll walk away. I mean, that's not saying the terms we're being offered are no more than is competitive in the market.
I think they go so far as to say that due to developments in the market since the date of our commitment, things are now considerably worse, but we will stick to our terms. That was the passage we saw this morning.
Yeah.
And then maybe Mr. Reeve, because he was asked about it as well. I'll let Mr. Bayfield do the bulk of his evidence, but one passage within the transcript, page 124. So 124, the bottom right-hand numbers, beginning at line 20, and this is where Mr. Thornton put to Mr. Reed that if there there were any changes to the pricing of the deal, they wouldn't walk away and let the company collapse. They would agree to the changes. So,
Sorry, I was in the wrong bundle. This is transcripts bundle.
my lord, I'm so sorry. Tab 1,
Yep, page.
page 124. The question beginning at line 20, I put it to you, Mr. Reid. The premise being, the question being put, that you wouldn't walk away if there was a change to the terms. And the answer beginning at line 25, and can I invite the court to read over the page, please, to line 7. So his evidence to the judge was that even if there were the minor changes to the pricing that would have been required by the Samsung and Saipem proposal, which would have required a cash payment to them and more warrants diluting the equity returns of the new investors, that would be unacceptable because of the risk reward of the new money. So we do respectfully suggest that when one puts together Mr. Caesar's evidence and his cross-examination, Mr. Reid's evidence and his cross-examination, the risk of the group more broadly as explained within the evidence and the consequences of something going wrong in one of those jurisdictions in relation to the small number of underlying contracts, the judge was absolutely entitled on the balance of the evidence to reach the findings he did in relation to the risks of the new money. Now we do, I think, respectfully suggest, focusing on the exchange before lunch, that using the Teneo document as an answer or as a worry to where that point goes, is that it would conflate the expert's view on the value of a business following a restructuring with the assumptions built in to that report on the one hand, with the views of an investor parting with new money to invest in the group on the other. Now, it's an obvious point, but one worth making. An investor of new money can decide to deploy its capital elsewhere. It will factor in the risks of the business. There are considerable risks due to the geography of operations, the small number of contracts, and as explained by Mr. Sousa, difficulties obtaining guarantees or bonding lines to support future business. That's all explained carefully in his evidence. And all of those risks underlie the difficulties faced by the group with the new money. Now, I think we would accept that things would be very different if there was no evidence at all of hard-fought negotiations and outreach. But we do respectfully suggest that one can focus on the point that was put this morning. I was asked, well, what about the evidence about those who didn't invest within the senior secured class? Then should we be expected to give the court evidence as to why they didn't invest in the business, despite what may be seen on its face to be a good return? We would put it in a rather different way. We'd say the real point is that when the court looks at the low take-up of the new money by those entitled to take it up under the plan, on the one hand, with the unwillingness of the participating creditors, including the AHG, to put up the full new money need on the other, one gets a compelling case which supports Mr. Sousa's written and oral evidence on the risks involved in the new money and the pricing of the new money. And indeed, one point of detail in that regard, the ad hoc group were not only unwilling to put in more new money, hence the need for us to find new money elsewhere, but they were reluctant to backstop the money. Some members of the ad hoc group would not backstop their pro rata share of the new money. That's Sousa 1, paragraph 10.27.2, supplemental bundle, tab 1, page 72. Now, if it really were right that the new money was disproportionate to the risk, one would expect at the very least for the ad hoc group to have provided the entirety of the new money, including backstopping the new money, rather than saying, no, we're not prepared to do any more than this. We see this as too risky. One wouldn't have Nuttree saying, no further changes, otherwise we walk away. One wouldn't have Mr. Reed giving the same evidence and Mr. Sousa giving that clear evidence. So in other words, it's our case that there was ample evidence for the findings that the judge did make on the facts of the case following cross-examination of the CFO of the group and Mr. Reed of the AHG. The court's seen what was put in cross-examination about their involvement in the deal. There was no suggestion during cross-examination that the pricing of the money was wrong. There was no evidence led by the appellants to suggest that the pricing of the new money was wrong. And in those circumstances, we do respectfully suggest that the appellants now really in this court should find it incredibly hard to advance that argument when both Mr. Sousa and Mr. Reed, in written evidence and in cross-examination, have dealt with pricing and the risk in clear terms. So has Nuttree, who it is common ground is key to the deal, and the judge has accepted that evidence. So while the court may have concerns in a broader sense for other deals in the future, we do suggest that picking up on the evidence in this case and comparing it and contrasting it, for example, with the evidence in a case such as Virgin, where Mr. Nicholson just said, I don't think we can get the money anywhere else in this market. The evidence is clear and detailed in this case. It is not a case in which there is no evidence to support where one has ended up on the pricing of the new money, and the uptake of the new money reflects that risk. Now, I'm mindful of the time in view of other points to cover. They are the key points. We've given all the references within the one-page document that we've handed up. Maybe I just pause to see whether the court has any further points on that before I move on.
Let's move on. Let's see.
May I make one more submission from my left, I'm reminded today. In relation to the outreach point, if it's right that you can't offer new money or justify the terms of new money under a plan without a fully competitive process in the market after supplying an enterprise valuation to all market participants. I'm reminded from my left and behind that in relation to a listed company such as this, that would cause near impossible MMPI issues. It depends what the court is contemplating in terms of the process required by the outreach. And we do say, therefore, that Virgin Active is right if the balance of the evidence shows there's been a hard-fought negotiation and the witness says, I just don't think we could have gone anywhere else. And the evidence bears that out in the sense that they've had to go very broadly to get the new money in. That, in our respectful submission, should be enough. The next point I was going to deal with was the appellant's new money rights. 2 points to make there. Number one, they did have such a right. That's clear on the terms of the plans and indeed the correspondence from Linklaters making that point. May I perhaps just give the court references to that? So first, in relation to Saipem, the Linklaters letter was sent on the 28th of April 2025. It was sent then because it was only asserted for the first time in the appellant's skeleton argument for trial that Saipem was not given a chance to participate. Supplemental bundle, tab 39, page 1172. Linklaters explained why under the terms of the plan they clearly had a right to participate. And the reference in the X plan for making that point good is supplemental bundle, tab 41, page 1217, paragraph 2.6.2.
1127, did you say?
1217.
1217.
Sorry, I'm so sorry if I
No,
misspoke.
I probably misheard you.
They are within, to be clear, they are within the definition at Roman 3. That includes both appellants.
This is the 25 million, correct?
My lord, yes it is.
And it's 25 million between them.
My lord, it is.
Yeah.
Samsung, the other participant, as the court knows, suggested it would be unlawful under Korean law to participate. They made that assertion for the first time in a witness statement served on, I think, the same day as the exchange of skeleton arguments by Mr. Delman, who's an American lawyer. The court may recall being shown that on Monday. That's supplemental bundle tab 9. Essentially, Mr. Delman gave hearsay evidence that he'd been told by the General Counsel of Samsung that it would be unlawful under Korean law to participate. There was no Korean law evidence, not even a memo making the point good. We worked hard, well, the team worked hard over the weekend securing an expert on no notice to provide the only Korean expert evidence to the court. That supplemental bundle, tab 19, page 767. And to give the court the reference, it's page 771. The conclusion, the first conclusion is the one at the top of the page at paragraph 20. Because it had been suggested in Mr. Delman's evidence that the articles didn't allow investment. And then if we could go to the bottom of the page, please. And then paragraph 25, the other point responding to, which was the assertion in Mr. Delman's evidence that there may be liability risks for management. And again, the answer is no. So this was the only independent evidence of Korean law, in fact, the only evidence of Korean law before the judge. So we say Samsung could participate, its evidence goes nowhere. I think the point's worse than that because, as my Lord Justice Snowden observed on Monday, the evidence doesn't really deal with whether they could invest on the assumption of a completed restructuring with listed debt. That's cantering through their entitlement. Then that disposes of grounds 2.1 and 2.2.
Is it your submission that if you're right about this, even if the new money is horribly overpriced, since you shared it with them, that's an answer? Is that your submission, or you didn't go that far?
My Lord, I don't go so far as to say that in a case in which there is egregiously priced money, the fact that you offer it around to everyone is enough to save your plan. I think I would have to accept that as a matter of fairness, the court would then need to consider in careful terms whether certain of those people had reasons why they couldn't participate. Now, of course, those sorts of internal restrictions are irrelevant to class, but potentially relevant to fairness. So no, we don't advance that case. What we do say is that they were offered participation rights on the same terms. In other words, we made them reflective of the bargain that had been made for new equity generally. I hope to deal with the other grounds more quickly.
When you say they reflect, sorry, I'm just being stupid. When you say they were reflective of the terms offered for new equity generally, can you just unpack that statement for me?
Well, of course I can. As explained, participating creditors have to take debt and equity, they have to take a mix. They have to do one-to-one. Because we couldn't fill the gap and we needed a lot more money, some of the money is coming in as equity only from new investors. And in relation to that equity, what is being achieved in the return on the equity offered to Samsung is the same as the return offered to the new money equity. Because the return for the participating lenders is blurred between debt and equity.
And where did the 25 million limit come from?
I think to give them the chance to participate.
Yeah, but why 25? Sorry, that's what I'm just struggling with.
I think if they'd been prepared and asked to do more, that would have readily been engaged with.
Right,
but
okay, so you're not saying that that was fixed by reference to anything. It's just a number, but the terms on which they could subscribe or take up that number was reflective of other things. I'm sorry, I'm just being slow, just trying to understand.
They offered it within the PIUL plan, where they have a claim of around 90 million. So the way that it worked in value terms, I think I may have explained earlier, participating creditors for every $100 of current debt are entitled to do $20 of new debt, assuming full participation. So if you have $100 of an existing secured claim, your pro rata share of the new money and new equity is $20. So it's a broadly similar ratio to that.
Okay.
That's where the figure comes from. May I go to ground 2.3, which I hope we can be brief on. Maybe I can just read it out to the court the judge was wrong to hold that no account ought to be taken of the fact that the appellants would be worse off under the restructuring plans. Now, we suggest that this is circular. It tries to reintroduce at discretion an argument which, on the assumption we're into ground 2 at all, we've won on ground 1 and the court has found that they are not worse off. Would the court like to see the way it's put in the ground? Would that help?
No, but the mere fact that they're no worse off, i.e. the jurisdictional test for cross-class cram-down is satisfied, is not an answer as to whether it should, in the exercise of discretion, be exercised. I mean, that's clear on the authorities. I mean, I'm just... The obvious proposition, namely that because you've established the jurisdictional test, ergo, you must be entitled to have cross-class cram-down in your favour, certainly isn't the case.
No, and I think I was quibbling with the worse off. We don't...
I mean, in other words, if somebody fails, it may just be the way you put it or I heard it, but if somebody opposes under 901G the existence of the power on the basis it said, okay, you are no worse off than you would be in the relevant alternative, they can still come along and say, yes, but I haven't got enough. You know, it's not enough. It's disproportionate or anything else. I mean, the mere fact they failed at 901G doesn't mean they can't bring back a sort of an argument that says, you know, I should have more. It's just...
I think we're in complete agreement.
Okay, fine. Okay.
What I was about to say is the way the ground is put makes no sense if it means the court should take into account now their interest as a competitor and the potential to exploit future contracts, which is what we think they mean in real language. That interest should now be relevant to the court when considering whether to sanction.
Right.
Then we say that should be given no weight because it clashes very clearly with the interests of the creditors as a whole. So we say in terms of weighting, where the purpose of a plan is to eliminate, reduce, prevent or mitigate the effects of financial difficulties, having found that the claim of a competitor is not in the no worse off test, it would be absurd, we would suggest, to allow it to defeat the plan at the discretion stage, when the plan is otherwise in the interests of the creditors and supported by them. Ground 2.4 is horizontal fairness. Now, this was taken very quickly already by the appellant, so I'll follow the court's lead, if I may, as to how quickly I should take it. They identified...
One point we would like help on, I think, is the HSBC. We're told that HSBC is getting 100% payout. Why? What's the justification?
My lord, of course. Can I go straight to that one then? Can I explain the background to the HSBC claim? It is currently owed $49.3 million in relation to performance guarantees by the group. The counterparty to that facility is PIL, so not one of the plan companies. It is a Jersey incorporated company. The facility under which HSBC is owed the debt by PIL is governed by UAE law. There is a guarantee of that facility by the plan company PL under a Jersey law governed guarantee. Can I show the court, please, Mr. Sousa's first witness statement where that point is dealt with? It's supplemental bundle, tab 1, page 82. supplemental tab 1, page 82. Does the court see the heading HSBC settlement? Mr. Sousa deals with the point through 11.8 to 11.13. I think the court's hands as to whether it would be helpful to summarise it or whether you would like.
Should we just read it quickly?
Thank you.
So is the expert? I mean, the expert report of Mr. Ali is to the effect that this plan won't be recognised in the UAE.
There's considerable, because this is a UAE governed contract, yes.
And none of the other contracts that are taken out by the
No,
plan
it's English law, that's why we're...
What, all the other claims under the plan are English law claims?
Yes, well, they are.
Right, okay.
So the problem is it would privatize horses through effectiveness.
Right, so it's a unique...
It is.
Creditor, okay.
Now, that evidence was not challenged in cross-examination. No evidence was adduced to suggest any of those points were wrong. And in those circumstances, when it wasn't even mentioned, I think, in Mr. Thornton's oral closing at trial, it's a little unfair to the judge to say he failed to address it. And maybe just the general point on that, paragraph 21 of the judgment, CB 7202, the judge makes clear he's considered all of the material and that he references those of the greatest materiality in his judgment. Now, bearing in mind the pressures the judge was working under, I would respectfully suggest that that is entirely fair, and to be criticised for not dealing with something that wasn't even raised in oral closings is a little unfair.
Right, well, I mean, there are two separate points. The first question is, should the judge have dealt with it, or was he wrong in not to have done so? Well, you've just made those submissions. As a matter of principle, I mean, we all know that under a scheme, you can choose who you propose the compromise or arrangement to, and provided that you explain to the people who you are requiring to take a compromise that there are some people just like them who are not, and explain to them why not. If under a scheme all the classes vote in favour, then the court on the face of it will say, well, that's their choice. They were properly informed. They decided, you know, although others were getting a better deal, there was a reason for it, and that's that. Now, that doesn't run in the same way under a plan, because by definition you haven't got the consent of every class. And so the same principle can't run in exactly the same way. I mean, as a matter of principle, how do you say the court should in any event approach this question?
As a matter of principle, and forgive me if we don't have it in the bundle, the Virgin Atlantic plan looked at the question of giving different deals to people who may otherwise rank pari, or excluding them from a plan.
The Virgin Atlantic plan, as it turned out, of course, was an unusual one, because in fact all the classes did vote in favour. So if you remember, I treated it as if it was an old-time scheme.
I'm talking in particular, though, of people who get a different deal and they're not included as a creditor under the plan, but the plan creditors are told this will be the deal that applies to this particular person.
That works where all the classes have voted in favour, because everybody thinks, okay, well, they may be the same as me, but they've been given a better deal, but okay, it's been explained why, and the class accepts that. And so under a scheme, or indeed Virgin Atlantic, all the classes, you know, the airline, all the classes had voted in favour. So in fact, it was just like an old-time scheme, and that's the way I approached it. But where you have a dissenting class, I'm just, and it may be that you know, don't want to commit yourself on this, but
very happy to.
But I just, what does the court do in the exercise of its discretion in deciding whether to cram down? I mean, how should it approach it? Do you have a submission?
Good or proper reason is what the court is looking to. And again, maybe just internal capacity needed in Virgin Active. I think one of the points that my lord made in relation to out of the money creditors is that in a future case, although it wasn't that one, it may be necessary to consider whether, if one group of out of the money creditors are getting paid in full while the other group are getting nothing, is that irrational treatment, I think, was the label used.
Well, as you remember, I was expecting perhaps, or at least it was at one point anticipated, that different groups of landlords might have a bit of a barney between themselves, and they didn't. But that's the context in which it would have arisen.
Exactly. But I think, again, we would suggest the court, to the extent there is this sort of treatment when determining whether it's a point that can raise a horizontal fairness point, which is the way it's put from the other side, looks to the touchstone of good and proper reason.
Okay.
Is it any different from the horizontal test between different classes in the plan?
Well, no.
So you've got to have a justification for treatment, like their critical creditor or something like that.
The only reason I hesitated slightly in that regard is because in Virgin Active it was said that's a point for another day, and it was put in terms of irrationality if you're out of the money, which may be a higher test. I don't know whether it would help to see the paragraph of the judgment on that.
No, not.
Sorry, arbitrary or capricious, I'm reminded with the words.
Yeah, and those, I undoubtedly borrowed those from Garuda, I think, in the first place, or something like them, yeah.
But whatever it is, we say the balance of the evidence in relation to HSBC clearly meets the test.
And that's because you couldn't do it under UAE law.
Look at this. Can I just, there were two other points raised orally. One was the Lithuanian project, and the other was HMRC. I mean, HMRC, I don't think was even mentioned in the skeleton. We were quite surprised to see that. I can deal with it if needed. In relation to Lithuania, can I maybe just give the court one reference which Mr. Thornton did not? He only showed the court Mr. Sousa's first statement dealing with the difference in treatment. Can I just please give the court the reference to Sousa 4, Supplemental Bundle 6, page 205. Beginning at 4.1, he deals with all of the other projects and why they're not treated in the same way as Thai oil. And just, if I can just show the court specifically in relation to the Lithuanian projects, it's page 208. The Lithuanian projects, for the court's note, are projects 4 and 5. And he deals carefully with, I think he gives at least 5 reasons why they need to be treated differently.
Is this right? You're saying this wasn't in any event dealt with in closing to the judge?
I think this was the only point that was mentioned in passing, but I think with no real exposition of it. It was just name checked.
Okay. We have the closing somewhere, do we?
The transcript. It's in the transcript, yes.
Okay. Well, perhaps you can just provide us at some point with the reference as to where those were mentioned.
I can hopefully.
You don't have to do it now. You can do it.
One other point within the evidence we just saw there, maybe I could just draw attention to in 4.5, the introduction to 4.5, so going up the page a little bit. Thank you. What Mr. Sousa does, in addition to the individual elements of why the Lithuanian projects are different, he explains at 4.5 why all of these contracts, including the Lithuanian project, are very different to the Thai oil project. And the reason for that, in essence, is that the planned companies are not contractors under the Thai oil project. So if you try and deal with the Thai oil project or exclude the Thai oil project, you would need, it can be done in a cleaner way. If you try and deal with each of these projects, you'd also need to compromise all of the subcontractor claims in relation to the projects, giving rise to material complexity and additional problems. So there's the general point at 4.5 that applies to all the projects, then 4.5.4 dealing with the Lithuanian projects in particular. And for the transcript, it's transcript day 3, page 406, lines 16 to 21 is when it was referred to in closing. Can I check whether I need to deal with any of the other horizontal points orally?
No, I think we will.
My lord, thank you. I was then going to move on very quickly to ground 2.5, which didn't get much airing really when opening the appeal. And that's the final ground of appeal. It's the judge wrongly placed no weight or placed insufficient weight on the open offer made by the appellants. Can I deal with that relatively quickly? The judge made a finding of fact that that offer was incapable of implementation. He accepted the evidence that no further concessions would be forthcoming from the new money providers. He accepted that the compromise under the plan was a delicate one with hard-fought negotiation. So that was the first reason he gave it no weight. The second reason was he also found that the appellant's offer was unfair. And that's paragraphs 29 and 57 of the judgment. As in view of time, can I just make the point good visually by reference to the annex to the appellant's skeleton argument that the court was shown? It's core bundle tab 3, page 41. Now, the purpose of this document, which the judge rejected at trial for the two reasons I've given, was to attempt to show that the offer made by Thailand really made no difference in terms of economics, because they were awarding themselves the same economics in bottom line total that they would have been getting under the plan if they put in the 25 million new money. That was the submission made. And maybe just for the court's benefit, and hopefully relatively briefly, does the court see the third vertical column, S&S offer, assuming no participation in further equity upside? So this is the offer the appellants put forward. And there are two fundamental problems with it, which led to the judge finding it couldn't be implemented and it was unfair. The first is in the top horizontal column, one will see it introduces a fixed amount of 25 million. This is the only scenario in which a debt obligation is owed by PL to Samsung and Saipem going forwards. And it does so in circumstances where it's common ground that no debt is allocated to the senior ranking secured claims because they get fully equitised. So that was the first fundamental problem with it. It was giving them a priority new money claim when the secured creditors were being fully equitised. The second fundamental problem, and the other way they generate value even though they're not putting any new money into the business, is if the court goes down to the horizontal column labelled warrant 1. And the court will see that in the first vertical column, which is the plans assuming there's no 25 million provided by the appellants, warrant 1 is worth between roughly 22 and 26.5 million to their group. Now, under the appellant's offer, they increase the value of warrant 1 to them and to them only threefold. And as the judge found, that can't be done because the clear evidence, oral evidence of Mr. Reed and Mr. Sousa is that wouldn't be agreed. And as a matter of fairness, the judge said it couldn't be done because that would then involve very differential treatment of some unsecured creditors versus, for example, the FISMA claimants who get a similar allocation of tranche 1 warrants. So it was suggesting they get 3 times as much as the other unsecured creditors. So that's why we say that the judge was right to give it no weight, and we respectfully suggest that ground 5 of the 2.5 of the appeal should be rejected for similar reasons. I see the time. I haven't quite got to where I wanted to get to, as the court will know, for which I apologise.
Well, what have you not dealt with that you wanted to deal with?
The virgin active point, that was the only thing. Otherwise,
Sorry, there are many virgin active points that I've been...
So sorry, let me clarify. The new money we've dealt with, the new money I say is fundamental, my lords have heard my submissions on that. It was, if the court is worried, in circumstances where
All right, this is the
the secured lenders voted entirely in favour, and they are the ones who have the benefit of the economic interest in PL in the relevant alternative,
well, it's the economic interest in the assets.
in essentially what would be the statutory liquidation trust within the relevant alternative.
Yeah.
They being happy with the new money pricing, having voted unanimously in favour of the plan, even those who are not doing the new money. No one from the secured group seeking to say there is a problem with the new money. Indeed, all the other unsecured classes supporting the plan and voting in favour, to the extent one even looks at them, that should, in our submission, be enough for the court.
Where do you say I said something similar to that in Virgin Active? Just you can just read the paragraphs into the transcript.
Well, I can. 237 through to 242 are key paragraphs. That's Appeal Bundle, tab 13, page 393. It's where the judgment deals with the impact of T Corp in the context of schemes and transfer schemes to leave people behind. The logical drive behind that being the liquidation trust would be for the benefit of those with an interest in the liquidation, and saying that general statement of principle is correct at 242, and that it applies with equal force in a Crown down under Part 26A.
So this is you're not trying to revive the argument that got squashed in Adler, are you?
No, absolutely not. We're not. Adler was a very different case.
Yeah, no, it was the Mr. Smith's attempt to argue that the plan was only fair if the shareholders were taken out.
We are not. What we say in relation to Adler is we recognise it establishes there needs to be a compromise or arrangement, even without the money creditors tick. And actually, on the facts of this case, as the court has seen, there are warrants going towards this group worth around $25 million. It's not a fraction of cents in the dollar return, as it was in Virgin Active. That's paragraph 29 of Virgin Active in the convening judgment, tab 12, page 313, paragraphs 266 to 267, fractions of pence in the pound. And really the rhetorical question we ask is, in circumstances where it is accepted and there's no appeal against this finding, that a liquidation is the relevant alternative, in which there would be no interest for the out-of-the-money creditors, it not being a close case here, there being over 600 million of unpaid secured debt before they have any interest in PL, how much does one pay them to allocate the benefits fairly? 5p, 10p, 20p? That's the sort of debate that we thought we were going to have on that point. And we don't, I want to be clear, we are not saying for a moment that anything in Thames is wrong. We accept Thames is absolutely right, and we rely in particular again for the transcript on pages 96, on paragraphs 96, 97 and 149 of Thames, which say that you can't rely on out of the money full stop as being an answer to a challenge in relation to the sharing of the benefits of the restructuring. But the Court of Appeal makes clear in that case it is context specific. And we do, and the court does say, reading, while it might well be right in some cases to conclude that the fact that a dissenting class would be out of the money in the relevant alternative is a sufficient justification to exclude them from whatever benefit the restructuring preserves or generates, that will not necessarily always be so. And that passage at 149 was in the context of the court being clear at paragraph 96, amongst others, that you need to look at it by reference to the relevant alternative in question. And so we do say that on the facts of this case, with the very considerable shortfall, one searches, we would suggest, for why there should be any allocation on fairness grounds other than that which is in the plan. We rely on the unanimous vote of the senior secured creditors. We rely on the need for the new money. We rely on, to the extent the court is concerned about the views of other out of the money creditors, the unanimous votes within, for example, the FSMA claimant class as well. That's, at a canter, in a nutshell, the point we make, which is we don't for a moment suggest that Virgin Active is a hard rule. Thames was right to say no, it's not. And we don't suggest it means you can give nothing. Adler says very clearly it means you can't give nothing. But what we do say is that when you look properly at the facts of the relevant alternative, it is a proper justification for giving very little of the restructuring surplus to out of the money groups, particularly in circumstances where they're so very clearly out of the money. Now, I'm not for a moment suggesting the point would be so binary if it was a very small sliver of value that they were out of the money by. I'm looking at clear cases like this one.
Is your point really that all that has to be done in a case like this, where they're so out of the money, is provide enough to make sure you have a compromise? Anything beyond that, you say you've given them more than that, which is a matter of within your gift. Is that really what you're saying?
My lord, yes. I mean, that's the bottom line, absolutely.
So you certainly can't pray and aid anything in Thames Water to support that. The furthest you can go, I think, is to say that that was an issue that was not dealt with in Thames Water because it wasn't addressing that sort of plan.
Well, absolutely. And I hope the passage I read out in Thames Water, I do pray and aid, actually, of the logic of where my submission ends up. That's tab 24 of the authorities, page 806, where when rejecting the rigid approach of the plan company, the court recognises that out of the money may be enough in some cases to say nothing. And we do say that a case in which there is a very large degree of out of the money and there is also new money going in and full equitisation of the senior secured debt, if that's not an example of such a case, we struggle to see what is. For example, it's not a mere amend and extend when the secured group keep the full amount of their claims and the unsecured disappear from the balance sheet. There is a very significant sacrifice by the secured creditors to generate the restructuring surplus. I recognise that's been done quickly, but that essentially
that's helpful.
Is the key point.
Right, thank you. So we are 25 past 3. Mr. Bayfield is next after a short break, I sense. Do you have any idea how long you're going to want?
Given that my learned friends need half an hour to 45 minutes to reply, I'm somewhat in your lordship's hands. I've already cut back what I was going to deal with to deal only really with the new money and in particular some parts of the evidence from Mr. Reed. I will try and be no more than about 10 to 15 minutes. I mean, it's unfortunate, but I think that's the position I'm in.
Okay, we may. We'll have a quick word and see when we can sit to, and we'll come back at past.
It's only assistance, whether we think we'll be about 30 minutes.
Okay, so it looks like we might finish by 4:30 anyway, but we'll come back at 3:30 and see where we get to.
Thank you, Lord.
just don't know. Because the order.
Good afternoon, Lord. Can I start by formally adopting the submissions made by my learned friend Mr. Allison, and I adopt them on behalf of the members of the ad hoc group? I don't intend to duplicate the submissions that he has made, particularly given the shortness of time, but I do want to make some brief submissions which I hope will complement the submissions that he has made. Well, Lord, I'd like to focus on the new money, and what I want to do first is to explain from the ad hoc group's perspective why the new money investment is not the windfall generating boon that your lordships appear to be concerned that it might be. Having done that, secondly, I want to highlight some points relating to the difficulties which were encountered in securing the new money. Mr. Allison's largely covered that ground, but there are some points to add. And then having done that, the third thing I'd like to do is to make some short miscellaneous points. So starting then, if I can, with the new money and the evidence. The evidence I want to take you to start off with is the evidence of Mr. Reed, who is a partner of Mason Capital, one of the members of the ad hoc group. He gave evidence both in his witness statement and under cross-examination as to the risk and rewards of the new money investment. And I'd like to start, please, with his witness statement, which is in the supplemental bundle at tab 5. And I want to start on page 167, please. And so on page 167, if we could scroll down a little bit, you'll find that there is a heading, the backstop fees. And as you can see from paragraph 31, Mr. Reed is addressing an attack by the JVPs on the backstop fees charged by those who backstop the new money. And what you'll see from paragraph 32 is a summary of the lack of appetite from the senior secured creditors or anyone else to backstop or provide the new money. And paragraph 33 goes on to deal with the position of the members of the ad hoc group themselves. So can I ask you to read paragraphs 32 and 33 to yourselves, please?
He says precarious liquidity position at the end of 33. He's referring to the unrestructured group, isn't he?
Yes, that's right. The key point in paragraph 33 is that of the members of the ad hoc group, 2 of them were not prepared to backstop their share of the money that was being backstopped in full. They wanted only to backstop a lower amount, which tells you something about the approach of even those 2 members of the ad hoc group to the new money investment. If, of course, the terms were extremely rich, one would have expected those members of the ad hoc group to have wanted to invest as much as they possibly could of the new money and therefore to have backstopped their full amount. And that wasn't the experience at that stage.
That stage being when were they asked to backstop?
We're dealing with a position here in towards the end of 2024, I think December. So we are talking about the period prior to the Teneo report being available. and at a time where plainly the members of the ad hoc group were having to take their own view, as they continue to do, in relation to the value of the new money investment. Reading on, paragraph 34 deals with attempts to find backstop providers from outside of the ad hoc group. So this isn't a situation of the ad hoc group wanting to try to keep all of the backstop fees to themselves and to lend as much of the new money, or to invest as much of the new money as was possible. And can I ask you please to read to yourself paragraph 35, which deals with the limited appetite from the senior secured creditors to backstop the new money after the launch of the plan. Again, if the terms of the new money investment were extremely rich, one would have expected those entitled to participate, not only to participate, but also be prepared to backstop and to earn the fee associated with that. And again, that was not the experience. Lord, paragraph 36 is also important. It explains why, in Mr. Reed's view, the new money investment carries significant risk. And can I ask you, therefore, to read paragraph 36 to yourselves?
Sorry, I was just trying to understand the cross-reference that he was making in that paragraph.
Reference to Mr. Sousa's evidence in footnote 12.
Yeah. This reference to performance guarantees.
Yes.
Where's, I mean, to the extent it's a risk, it's in the valuation, but I'm just struggling to understand what these performance guarantees are that they're talking about.
Well, as I understand it, and this will be a very amateur response to my lord, but with companies such as Petrofac, when they're embarking upon a project with a client, performance guarantees are required to be given, and one needs to identify lenders prepared to offer the performance guarantee. and that will be part and parcel of being able to win a contract. And that's where Petrofac has been struggling in terms of being able to find lenders prepared to give those performance guarantees.
Is that this is different, is it, from the injection of $80 million under the CBG facility?
Yeah, well, that facility is there to facilitate the giving of guarantees, but the idea is that once the group is back up and running and restructured, guarantees will be available in the fullness of time from the market to enable them to continue to win new contracts.
Right, but that's just an ordinary. I mean, they've got money, 80 million, under the plan to provide collateral for performance guarantees. I thought that's what I'd understood.
Yeah, I think that's rather small fry, though, my lord. 80 million is a drop in the ocean in terms of the amount of money that is required by way of performance guarantees going forwards.
What but that's factored into the. Is that not factored in any event, though?
Well, I don't know what my lord means by is it factored in.
Sorry, to the valuation.
It's factored in the sense that the business plan that management have produced and which Teneo have looked at is premised on the ability in future to be able to obtain performance guarantees.
Yeah.
That is something that Teneo may have asked management about and questioned them on, and the risk of not being able to get performance guarantees may be factored into the valuation.
It's the very first thing that Teneo took into account as the key issue in trading uncertainties in their valuation.
Quite. But what Teneo can't be sure about is how the market will respond and whether performance guarantees will be available. It's not Teneo that are taking the risk as to whether that will happen or not. It's those that are making the new money investment. And so whilst we are not trying to distance ourselves from the Teneo valuation report, looked at in the real world of the position of someone that may or may not invest in the new money, they will have to take their own view. As we'll see from the evidence in due course, the Teneo report is plainly something that is of relevance and of interest to a creditor such as Mason Capital, but their report is not the be-all and end-all. Well, can I take you to the live evidence that was given by Mr. Reid? He was cross-examined by my learned friend, Mr. Thornton, and I want to show you some limited extracts from the cross-examination. I should say that he wasn't cross-examined on the terms of the new money and them being too rich, but I will show you what he was cross-examined on that is relevant. For this, we need to go to the transcripts bundle and tab 1. Cross-examination of Mr. Reid starts at page 99. I want to start, please, on page 100. And if we could please go to page 100 and scroll down to line 16. At line 16, Mr. Thornton asked a question about Mason Capital's intentions as regards holding onto the new money securities in the long term. Can I ask you to read, please, from line 16 on this page, just to line 2 on the following page, please. And in answer to the question that you have just read at line 3 on page 101, what Mr. Reid says is, I think there is a range of potential valuations for the company. We've underwritten a range of potential valuations. Those potential outcomes I'm not at liberty to share given confidentiality arrangements and marketing restrictions in the US, but I will say that there is a range of outcomes here of which the Teneo valuation is not unreasonable, but I guess there's a range depending on many factors that are uncertain and risky in the future. If we can now move on, please, to page 102 at the top of the page. Here, Mr. Reid was responding to questions about whether he considers the new money debt to be low risk. That was put to him. And can I ask you to read what he says in relation to that by reading, please, from line 1 on page 102, right the way down to line 20, please.
I think we're there.
It wasn't put to him that he was in fact wrong and that was ridiculous, and that the warrants and the debt were obviously very safe investments. What would then happen was that Mr. Thornton introduced the proposal that had been put by the JVPs for an alternative arrangement. And could we please go to page 104, where in response to that line of questioning, at line 4, Mr. Reed says this, and also for my own capital, I think it's important to know that this is largely a new money deal, and the economics are going to be for the new money here. And the new money is a significant multiple of the current old money value. And anything that jeopardises the balance sheet of the company, which this 25 million cash out payment does, could jeopardise the ability of the company to get future bank guarantees on which the business plan is entirely reliant. So anything that jeopardises the company's ability to get those bank guarantees, of which this 25 million payment is one, is a risk, you know, I'm unprepared to take for our new capital coming into this situation. So the evidence there was that Mr. Reed was concerned that even giving a 25 million debt repayable over a period of years to the JVPs might interfere with the ability of Petrofac to get future bank guarantees on which the business plan is entirely reliant, and that the new money wouldn't be lent on that basis.
Just to understand that, I'm not sure whether this is where he's being asked effectively about the plan A, plan B, in essence here. And he says this is important to know, this is largely a new money deal. The economics are going to the new money, and it's a significant multiple of the current old money. I'm not sure I see the connection between that statement, which seems to be his position, and then the second sentence. It may be me, but I'm just not sure what I can understand the connection between the two.
Well, there may not be a clear connection, but what he's saying is that in relation to the new capital coming into the situation, and that's line 16, it is sufficiently risky that if the 25 million cash out payment was included, that might jeopardise the ability to get future bank guarantees, and the new capital wouldn't be invested on that basis. And my lord, really the point is this, that if the terms of the new money were so rich, then plainly Petrofac taking on a debt of $25 million would be neither here nor there, wouldn't move the needle and would be acceptable. But the evidence from Mr. Reed was that that was not the case. Well, just to come back to a point I made about the 80 million under the CBG facility not being terribly material, being a drop in the ocean. If we could go to the supplemental bundle at 1489.
Yeah, there's footnote 1 and the
1489.
Yeah, and it's the
bottom bullet point on in the column headed description,
And the footnote.
you can just see what the amount in aggregate is of the total estimated new orders. And whilst the performance guarantees won't be in that amount, one can well see that a facility of 80 million isn't going to take Petrofac very far. I think I can put the point higher than that.
Yeah, and we understand. And they note, in fact, the management takes the view that this is a conservative assumption in the timeline, and they think they can get guarantees on normal commercial terms much quicker.
And that will be critical to the success of
Well, it's
the
factored
group
in.
going forward.
It's a risk factor that's factored into the valuation.
It is,
Sorry,
my lord. But the point is, one can fixate on the Teneo valuation. That's not what the people who are being offered the opportunity to participate in the new money are necessarily doing. One has seen what Mr. Reid has said about that, and as we'll come on to, others who have been offered the opportunity to participate in the new money, including those who have seen the Teneo valuation report, have not leapt at the opportunity to do so.
Yeah, I mean, I understand that point, although I would quibble with the idea that the court would be, quotes, fixating on a valuation report which is produced in all these plans and schemes as an essential part of the evidence that goes in front of creditors and the court.
My lord, and I understand why you would put it that way, and plainly it is not something which we are submitting is wrong. We don't need to do that. It's a critical piece of the evidence in terms of the court being satisfied, for example, that the no worse off test is met, and so on and so forth. The point, though, is that it shouldn't dictate that the court concludes that the pricing of the new money is too rich when the evidence which is available to the court in terms of who is subscribing to the new money, who is not subscribing to the new money, and the views they take of the risk and reward of the new money investment dictates that that's not the case.
We've got evidence from those who have invested, I think.
Yeah.
We don't have evidence, do we, from those who didn't take up the option as to why they didn't.
No, my lord, one doesn't have that. Mr. Allison dealt with the point earlier. What we'll come on to in a few minutes is this, that we do know that those who were given the opportunity to participate as senior secured creditors and who have passed up that opportunity still consider the plan to be in their interest, because a number of them, I'll come on to the numbers in the chair's report, have voted in favour. And we also know that none of them have come to the court to say that the terms of the new money are far too rich. That is why they are getting a fairly modest return on their old money, that they're not able to participate in the new money for whatever reason, and that renders the plan unfair. Quite the opposite. There's not any opposition, not a single vote against from that class, and a number of votes in favour of the plan from those who are not participating in the new money. And that does send the court a very clear message that those sophisticated plan creditors, and I say sophisticated because they are existing creditors of Petrofac at senior secured level, they have not taken the view that there is anything untoward in the terms of the new money or this plan.
We probably need to get on to your second point, I think.
Before I do that, can I just show you some live evidence from Mr. Souza, Petrofac's CFO, about the business plan? So we're back to the transcripts bundle for this, please. And could we go to page 43? Here Mr. Thornton is putting questions to Mr. Souza about whether the new money notes and the new money equity carry risk. That starts at line 3, where Mr. Thornton asks whether it's a necessary assumption that the new money deal will be fully recoverable for the new money equity to have value. Sorry, the new money debt will be fully recoverable for the new money equity to have value. And at line 16, it's put to Mr. Souza that the new money debt is low risk. Can I ask you to read Mr. Souza's response to that, which starts at line 17 and goes over the page to line 2 on page 44?
Were we not shown this?
We haven't been shown.
Great. Then we can.
I'm just conscious, if you can keep your eye on the clock, please, because I am conscious if you're still in your first point.
Okay, and Can I ask you then whether you could... Have you been shown, please, on page 44, the passage starting at line 17?
We're asked to read all the way to page 46, line 8.
Then I'm grateful and I will move on to my second point. The second point is about the difficulty in obtaining the new money. As I say, Mr. Allison's already dealt with that in some detail. I was going to give you some paragraph references to the evidence, but I won't do that in the interest of time. Mr. Sousa was asked under re-examination what would happen to the group if the plans were not sanctioned. And can I just show you his response to that, which is on page 97 of the transcript? And can I ask you please to read from line 4 down to line 12.
Is this just an inter orem point, or I mean, what?
Well, my lord, the point is that Mr. Sousa says that they've strained every sinew to raise the new money. If it were easy or readily available to get money on better terms than those that are on offer to the new money investors, then that would be inconsistent with his evidence.
Did he strain every sinew by going into the market, as opposed to engaging in hard negotiations with the ad hoc group?
Well, my lord, as you know, it's not only the ad hoc group that are lending the new money. This is the point that I was going to come on to. It is not the case that only insiders to the company, creditors and shareholders, are lending the new money. So that we do know that new money investments have had to be sought from outside of the ad hoc group, outside of the senior secureds and outside of the existing shareholder base. This is an important point. As my lord, your lordships know, Nuttree, which at the time it agreed to lend 125 million of new money, was not a creditor or a shareholder. It has subsequently bought in a small amount of debt, but at the time it was an outsider. It's come in to lend 125 million of the new money. If the terms of the new money are so rich, it rather begs the question why the ad hoc group and others were not prepared to lend all of it, and why they were prepared to go outside of the group and the insiders to find people prepared to lend new money.
I mean, we don't actually. Is there any actual explanation of who Nuttree are and how they were introduced to the piece?
Yes, I think Mason Capital went and found them and introduced them. I think that's dealt with Mr. Reed's evidence. I can ask
just
Mr.
get a
Merkel to get you the reference for that. And you've also been shown the letter that they sent and which was relied upon before the judge.
Yep.
The same point goes for the additional equity investors, which were neither shareholders nor creditors nor directors of Petrofac. The evidence doesn't deal with the amount of the additional equity investor new money which is being invested by them, i.e. non-insiders on any view. I'm told on instructions, for what it's worth, that they are lending 33.5 million of the additional equity investor debt, and that a further 18 million of that debt is being invested by someone who was previously a shareholder, but not at the time they came in to lend that new money. So again, the same point is, if the terms of the new money were so rich, why is there such a variety of people lending it? Why haven't the ad hoc group lent it all, or rather invested it all themselves? And then we do make the point in relation to the senior secured creditors. And for that, can I ask if you could go to the supplemental bundle at page 259 and down to paragraph 9.1, please. This is the chair's report of the meetings. And what you will see is that 81 senior secured funded creditors, excluding the ad hoc group, voted at the plan meetings. They all voted in favour, and of them 25, holding almost $73 million by value, are not participating in the new money. The new money was open until the day after the meetings, but I can tell you again on instructions that that position didn't change in the day post-meetings. So what the court knows is that 25 sophisticated plan creditors not only passed on the opportunity to invest in the new money, but still considered the plan to be in their interest and actively voted in favour of it, plainly not concerned that the new money terms were too rich.
But they're all getting a better deal than they were getting the relevant alternative.
Sorry, my lord?
Yes, I mean, okay, I mean, there's only so far you can take that point, because, I mean, the point is that they're all getting a much better deal than they would get in the relevant alternative.
Well, actually, my lord, they're only getting a modestly better return
Okay,
than they would in the relevant alternative. And
but it's relative. It's somewhere between the unsecureds and the participating.
But my lord, I would query with that way of looking at it. What one needs to do is to compare what the return for them would be in the relevant alternative with the return that they get under the plan. And that is only modestly better. One can equally make the same point in relation to the JVPs. Well, why are they complaining about the new money? They do better under the plan than the relevant alternative. So the point very much cuts both ways. And the point is an important one. The non-participating senior secured creditors really do only do marginally better under the plan than in the relevant alternative. We can look at the numbers if you like. It's in the agreed summary of key figures. And it's the table above paragraph 23, where on a low case return, they would be getting 24.3% in the relevant alternative, and they'll be getting 28.8% through the plan.
Yeah, so that's what I had in mind, yep.
So notwithstanding that the plan only benefits them to that fairly limited extent, they've actively voted in favour of it. Now, that would be a very curious thing for them to do if they took the view that the new money terms were extremely rich. And of course, if they thought the new money terms were extremely rich, they've had the opportunity to lend and they have passed it up. Or for whatever reason, they can't lend, but they don't complain about that. So that does tell the court something quite important about the terms of the new money. And they, of course, have seen the Teneo valuation report. My lord, the few miscellaneous points before I sit down, and I'm sorry that I'm having to go as quickly as I am. The first point is that it is stark that the JVPs are the only plan creditors who have opposed these plans. As I've just dealt with, the non-participating senior secured creditors don't oppose it. In fact, all of them that voted in favour. And additionally, there are other unsecured creditors who are not participating in the new money and who are treated in materially the same way as the JVPs, and none of them oppose the plans either. The second point, which may shine a light on that, is that the JVPs have made no secret of the fact that they consider that they would be better off in their capacity as competitors of Petrofac if Petrofac were to go out of business. Now, whilst their motivations for the challenge can't possibly dictate the result of the appeal, it may call into question why they are the only people opposing these plans. Very, very briefly, my third point is a point that I think Lord Justice Zacaroli already has. In the context of a Part 26A plan, where some creditors are being left out of the plan altogether, effectively the question for those who are included in the plan and who would rank alongside or behind, who would rank alongside or in front of those being left out of the plan, is whether there is a good justification for the differential treatment of those being left out of the plan. Just as this court in Adler applied the is there a good justification for differential treatment of like-positioned creditors in the relevant alternative, the same test should apply where creditors who are in the same position are being treated differently, whether or not they are being treated differently under the terms of the plan or by being left outside of it. Lords, the final point I just wanted to make is in relation to the approach to out-of-the-money creditors. We agree with the submissions that Mr. Allison has made in relation to them, but can I just make one point to try and tie some of the points in the authorities together? There will always be arguments potentially available to out-of-the-money creditors which go to the fairness of the plan, notwithstanding that they are out of the money. For example, and on the point we were just on, they might be able to complain if other creditors who would rank alongside them or behind them in the relevant alternative are being treated better than them without justification. And the point that I make is that they do therefore have a voice, and the authorities which say that if you're out of the money you have no or little voice go too far if they are to be taken as suggesting that out-of-the-money creditors are prevented from taking points of that type. But it's not inconsistent with that to say that where someone would get nothing in the relevant alternative, that must feature large in valuing their contribution to the generation of the benefits of the restructuring. I.e., if the benefits of the restructuring are created through new money and through the writing off of debt which is in the money in the relevant alternative, the value that one ascribes to those contributions is of a different order.
The value of the equity which is created in a post-restructuring vehicle that survives and trades is in part enhanced not only by the writing off of the in-the-money debt, but it's enhanced by the writing off of the out-of-the-money debt.
Precisely, and what I'm not quibbling with that. What I'm suggesting is that when you look at the value of those contributions, which you need to do to explore whether the benefits of the restructuring are being distributed or shared appropriately, you have to look at the nature of the contribution, the value of the contribution, the relevant alternative to be able to do that. So, for example, if one is looking at new money as contributing to the benefits of the restructuring, well, in the relevant alternative, those providing the new money are entitled to deploy that new money however they so wish and on whatever terms they consider appropriate wherever. That is a much more valuable contribution to the contribution of someone who writes off their debt when in the relevant alternative they would get nothing.
I think that's the point I made in probably Virgin Active.
Yes, it is, my lord. And what we suggest is that is absolutely right. That doesn't mean that they're not making a contribution. That doesn't mean that they have no voice. It merely reflects that the contribution that they're making is of far less value in the real world. I'm sorry for exceeding my time, but unless you have any questions for me, those are our submissions.
No, thank you very much, Mr. Thornton. Just give me 1 second. Okay, right. Where you go.
We're going to split the submissions, so I'm going to deal with ground 1. Mr. Colcott's going to deal with ground 2.
Yeah, I think you're safe until at 4:45, but
Right.
then we'll see where we are between you.
We will do our best to finish.
I think that gives you the time you said you thought you'd need.
It does. Thank you. So, my lord, during the exchanges that you had with Mr. Allison yesterday, there was some discussion around an approach to the no worse off test by reference to considering how the legal rights held by a creditor or indeed a member are impacted by the plan. And on that test, when assessing whether the any worse test is met, the court would look at the legal rights held by the stakeholder proposed to be crammed down and ask whether they were any worse off comparing, on the one hand, the impact on those rights of the relevant alternative, and on the other, the impact on those rights of the plan. And I think, as my Lord Justice Snowden pointed out, in looking at what those legal rights were, you would look not just at the rights in the narrow sense as between the planned company and the stakeholder, you would also look at relevant rights they may have against third parties that were impacted by the plan. Now, clearly, my lords, that would be an approach that draws somewhat on the history of the class test that we apply when we look at the question of class constitution, where we look at the rights taken into the scheme and out of the scheme, as you raised yesterday, Lord Justice Snowden. And the question there is whether either the rights are the same, or if they're not the same, is the difference so dissimilar to make it impossible for the relevant stakeholders to get in the same room to consider the scheme in that case in their mutual interest. And a clear consequence of that approach is to draw a line, a very clear line, between matters which go to legal rights, which would be said to be jurisdictional, so in this case under 901G, and those rights that would go to discretion, or those interests that would go to discretion, which would only come in at the later stage, and somewhat chimes with the approach that Mr. Justice Trower took in Deep Ocean, albeit by reference to a different test. So it would be a rights test rather than a capacity test. But you may recall that he drew the distinction.
Putting it very shortly, the classic way on which schemes have always been formulated and which plans now build is you draw a distinction between rights and interests.
Indeed. And the attraction of that test is that, of course, it dealt with all the edge cases that you were debating with Mr. Allison yesterday, the guarantees, the financial advice, the third-party claim, and so forth, because those would each be cases where legal rights were impacted, and you could price them in. And I think your Lordship, accepted the submission we made that when one gets to questions of quantification, if the reality is the quantification of the effect on those rights is complicated, well, that's just part and parcel of the process. So if there is an impact on a third-party right, your example of a claim against a financial advisor, if that is difficult to quantify, so be it. But it has to be quantified. So one can see why that is an attractive starting point. And I think what we wanted to, the points we really wanted to make is to really caution the court against adopting it as the only test in every case, to say only if you can show an impact of the plan on your legal rights can you make a submission that you are worse off. And we say that there are a number of reasons for doing that. And the first is that the focus of the statute, the no worse off test, is on the economic outcome of the plan. And therefore, when one looks at the position of a creditor or a member under the plan and under the relevant alternative, we're essentially looking at how they work through on a financial basis. And where one is asking the class question in relation to a scheme, the test of looking at rights and not interests fits very snugly with other provisions in the Companies Act. So, for example, when one looks at the test for a class of share under Section 629, what that provision says is that there is a class of share if the rights attached to them are in all respects uniform. So there's a very clear reason to move across when one's talking about a class test to fix on the same test, or a very similar test to one we fix on when we look at class of share. And of course, we know there's more flexibility in the class of member test than there is in a member's context, and the class of creditor test than there is class of share, because class of share requires uniformity. But there is a history of looking to rights in the context of a question of class. But we say it's not as obvious a starting point when one's looking at an any worse off test. There's no reference to class in the statute in that respect.
Except 901G does talk about that the test is whether members of the class are any worse off. I mean, so you are sort of, in a sense, the whole class concept is baked into it.
Well, it It is, but that comes from the earlier part of the statute, because you're looking at a dissenting class.
But
and it
why
has
at
been
this stage on a jurisdictional test do you suddenly introduce some new concept which you haven't been using when you've been determining the class question? Why don't you just bring these wider interests, if that's what they are, in at the final discretion stage? Why do they come in at the jurisdiction? I think this is essentially what Mr. Sorry, it's been
Mr. Allison.
Mr. Allison, I do apologise. Your submissions are memorable. So sorry. What Mr. Allison was saying, that it's the wrong point in the process to bring in your non-rights-based considerations.
Because the question that's been posed is there essentially, are the economics justified in relation to that class? It's not a question of saying, are the rights attached to those shares economically worse off? The test is, are the members of the class worse off? And it's an economic test. And we say, therefore, that if you can show that there is an obvious economic impact derived from the plan that impacts that particular class of creditor, that can come in at that stage.
Why don't you say, are they economically worse off by reference to the effect that the plan has on their rights? Doesn't it work equally well to put the question in that form and leave questions of discretion about economic effects which don't derive from interference with rights to sanction? To discretion, sorry.
It's the point I made in opening, that you bear in mind, when you get through to the discretion test, you face the argument, because the court can't look at them in the same way when one gets to a discretion test, when it's looking at pure economic consequence, because you face the arguments being put together today that, well, even if they economically are detrimental to you, when you get to the discretion test, they have to be looked at in the round against the impact on lots of other people too. And 901G focuses on, it's my isolation or vacuum point, you're focusing on the class that is being forced into the bargain against their wishes and the economic impact on them in isolation under 901G. When you get into the question of discretion, you are not doing that. You are looking at it in the round. So they are they're in a much weaker position running it as a discretionary case. And I'm not suggesting for the moment, I'm not suggesting that perhaps the starting point in every case and maybe the end point in lots of cases will be looking at the impact on legal rights. However, what I would say is that one shouldn't close the category in every case to those legal rights. Now, I don't suggest that it's not a difficult burden for somebody to take a court beyond those rights, but when there is, as we say here, a clear and obvious impact on our economic position through the plan, competition points, those are sufficiently connected, and that's why we went in an alternative case to sufficiently connected to that relationship of debtor and creditor for them to be taken into account at that prior stage and not to be lost in the mix that inevitably arises when one gets to the discretion stage. So it was really simply to implore the court that when applying a very broad test that Parliament set of any worse off, tying it in every case only to rights may be too narrow an option. We say that in this case, this is an edge case, it's an example of a situation where there are clear economic detriments for my clients tied to the plan that justify considering those at the 901G stage and not losing them within the broader series of factors that are taken out in the discretionary stage. And so that was the point we just wanted to make in relation to that issue that emerged during your exchange with Mr. Allison yesterday. So unless you had any further points on that one, Mr. Colflough was going to address point 2.
Thank you.
Well, I'm going to be brief as well. 2 points that I think the court has, but I just want to make them again to make sure the court does have them, is that when we're talking about equity valuation in this case, we are talking about day one equity valuation. So when submissions are made about future contracts and what may or may not happen in the future, that isn't relevant, save to the extent that the inherent risk of those things happening or not happening have or have not been factored into the valuation exercise. And for all the reasons, well, in fact, on all the various pages of the valuation report that we've seen, they plainly were in this case. So that's the first point I'd just like the court to have.
Point made against you is that's only half the story, because someone wanting to invest may well see that a value is valued at X, but they're looking at the long-term risk, looking forward. Will they get their money back in the future? And that's only part of the story for them.
Well, the valuation evidence before the court. So that, in fact,
Well, I think your answer in part to that is these are traded securities and traded debt instruments.
it is that's part of it. But can I just quickly show the court the same table that Mr. Bayfield took the court to, which is in the agreed notes above paragraph 23. So this is the analysis of the plan companies. These are the numbers on which the entirety of this exercise of sanctioning these plans are based, and they are based on the value in the hands of the creditors on day one. That is the focus. So in my submission, that ought to be the start and the end point, and I obviously endorse my Lord Justice
Is there
Snowden's
any evidence as to what the trading price of these things
will be on day one.
has been through this process, will be on day one?
No.
Well, they're not traded.
Well,
60.
yes.
Okay. Existing debt.
Oh yeah, but you need your money.
Yeah, that's true.
The equity or the debt. I mean, what?
It's different equity and different debt, isn't it?
Yeah. So I mean, I'm afraid I don't know the answer. If that's we can get that.
I mean, what's currently traded is not the expanded post restructuring equity or the new debt.
Exactly. It's not the shares that appear on this.
Yeah, we don't know what's been going on. I mean,
No, we have. And it relates to my second point, which again I'd ask the court to have this in mind. Is that the plan companies are in a very difficult position when they make the submissions that they do about value, because we can see from that table, Mr. Bayfield made the point in support of these plans, that the non-participating secured lenders are marginally better off, not Mr. Bayfield's words, entirely driven by the equity valuation of 1.5 to 1.85. That's what this is based on. So if the submission is made, and I think it is, that there is a real risk with these numbers, enormous risk is the phrase used in the skeleton, then the plan companies have a real problem, because that means there is an enormous risk that these non-participating senior creditors are worse off, given that their returns are derived entirely from the equity and the equity valuations which the plan companies now seek to partly go behind. And these creditors have not been told that. And the related point is it means that the warrants given to us are worthless, or there's enormous risk that they're worthless, and Saipem and Samsung end up with almost nothing from this restructure.
or indeed, I think you say in your skeleton nothing, which would mean that that it's akin to not a compromise or arrangement, but just expropriation, other than they get instruments of purely speculative value.
Well, we get some cash, so I think
That's so you'd accept that at least jurisdictionally saves it.
yes, we've never ran a jurisdiction point. We were asked by the judge at convening whether we were going to, and we didn't take that point. But the return is very, very small if the equity valuations are missed. They're wrong.
Yeah, I mean, there was a hint of that in your skeleton. I think that was all I was just trying to. Yeah. Okay. Well, so paragraph 61 of your skeleton is not a jurisdiction point in disguise.
It's not. No, we haven't taken that point. I'm not taking it now. The very final thing I wanted to deal with, conscious of the time, Mr. Perkins took the court through some numbers this morning. We handed up a note, which I hope you have. It's headed Note New Money Returns. I take the court through this 3 or 4 minutes, I hope, at a canter. Just so the court knows where we are, Mr. Perkins' numbers came across to us this morning at 9 a.m. I've not had a chance to check them yet. I've done a sort of quick calculation. I think we're about 1 or 2% apart, so that they are directionally the same. So no doubt we are going to be able to agree those numbers tomorrow, and we'll give the courts one set of numbers so that the court has that for the judgment. But we've done sort of the same thing, but we've tried to present it by breaking it down into the different components of the new money. So if my lords can start on the second page of the note, paragraph 6, the table, which that's the one that we've just seen. Then we break down the participating senior lenders' outcomes by reference to the sort of bucket of consideration. So it's just over 100 million for existing claims, 70 to 86 for fees, and then the gross new money returns are 711 to 835, broken down 536 to 660 for new money equity, on a commitment of 93 million. So you put 93 million in on day 0, and on day 1 you get back somewhere between 536 and 660 is the evidence. And then 175 million in new money debt on a commitment of 93.8. Just so the court understands what that number comprises. It comprises the face value of the debt, plus the OID, plus the reinstated notes, but it doesn't include future interest. So it's just the face value of that debt instrument, plus its sort of fee components as well. So that's the participating senior lenders. At paragraph 9, we move on to Nuttree. Nuttree, 125 million, 37.5 equity, 37.5 notes, 50 million of CBG notes. The 125 on day 0 leads to returns on day 1. Valuation evidence of 269 to 304, comprising equity 127.157 plus fees on the equity of 25 to 30. And on the next page, notes of the top of the final page, new money notes of 44 million on the same basis. It's the face value of the debt, no interest, plus the OID. And then there's a CBG structure, so there is the obligation from the SPV to repay the 50 million. So those are the notes from the SPV, and there are fees of 23 million, 12 million of new money notes from PL cash, and then contingent value rights. Paragraph 10 is the other member of the AHG in the CBG notes, and then the final category, paragraph 11, additional equity investors. A mix. We've heard of insiders and outsiders. I'll have to check the transcript. Mr. Bayfield gave us the breakdown, but they put in 87.5 on day 0, equity only, and get back 415 to 512 on day 1. So then when you break it down, and in fact, 12.1 contributions in 430. Slightly different from the plan company's 444. We're going to have to try and reconcile that. That's the retail bit that the court heard submissions about on Monday. We'll get to a reconciliation. 12.2, the total day 1 return on the new money, excluding fees, this is a gross number, is 1.4, just under 1.4 billion to just over 1.6 billion. And at this point, if I can just show the court the numbers that Mr. Perkins showed the court this morning, just so you can see that we are quite close to the group.
Can I just pause for 1 second?
Yes.
Paragraph 11, you've got the additional equity investors. Have you got the single page, what I called the breakout of the new money providers table that we were given?
It's in, there's one in the agreed notes. Is that? Oh yeah. Oh, the one. Yes, that one. Yes, I have that. Yes.
So I'm just trying to read through this note alongside that. So that final category of participant is the additional equity investors.
Yes.
They're going to contribute 87.5 for new money equity only. Where are they?
In the other, in the single page, they are in the line other new money providers, which is 181, and the difference between my 87.5 and the plan company's 181 is that the ad hoc group CBG contributions can be found in that bucket, and there is the future retail fundraise included in that line as well. I think that's where the difference.
Well, only because if you're contributing 87.5 million for new money equity and your day one return is between 415 and 512 million, I think even my dodgy maths suggests you're going to get more than the percentage uplift that appears at line note 6.
Yeah, and the reason for that is
It's blended again, isn't it?
It's blended with the ad hoc group's contribution to the CBG notes, which is the lowest percentage of all the new money buckets. So when you blend those together, you get a much smaller number than in our notes. If whilst we're on the plan company's numbers, just to show how close we are, it's a 200 and these are net figures in the plan company's analysis. 211 to 271% day 0 to day 1 return. Our net figure, well, our gross figure is 320 to 379. Our net figure is 220 to 279. So we are. We just need to sort out those final few single digits.
Precise numbers don't really matter.
It doesn't. And your lordships know the submission I'm going to make about these numbers. They speak.
They speak themselves. One point put against you is that there was evidence below, Mr. Sousa, Mr. Reed, about the difficulty they experienced in obtaining money on anything other than the terms that they ended up with. And it said that there was no cross-examination of those witnesses on the basis, for example, that had they gone to the market, they could have got it much cheaper. Is that right? There wasn't any cross-examination on that basis. There's no evidence from you to that effect.
There was certainly no evidence. I have to check the exact scope of the cross-examination. But the point that we've made all along, it's always been our case, is that for a start, the evidence looks at the wrong thing. The evidence looks at fundraising in the context of a distressed company, not at the day one. And your lordship has that point. And it's the plan companies who had the evidential burden to satisfy the court. And they didn't put any expert evidence of what market rates were. So that's always been our point. And we also say on value.
Was it always your point below that they hadn't put expert evidence?
Well,
I challenged them to do that.
Well, I'm not sure there's been a formal challenge, but our case has always been. I can show you the skeleton below where we have a table which shows contributions in new money providers, senior secured creditors, us, and we're saying this is totally disproportionate, and it's driven by the delta between the 351 and the 1.5 and the new money equity, and that's what drives, and that's always been the central part of our case throughout. No one's had any doubt about that.
I mean, the judge plainly understood that your challenge is the terms of the new money disproportionate? Because if, for example, I keep coming back to it, but paragraph 89, 1A, he comes to a conclusion that he says, I see nothing disproportionate in a return of 211%. And my understanding is that the 211% he's referring to is the blended number that you see in the table for new money providers. So my understanding is that you've always said it's disproportionate. I think my Lord's question to you, though, is, well, you say it's disproportionate, but did you introduce any evidence to say, if this company had gone into the market, to say, leave us to sort out the restructuring, what will you now charge us for 350 million of new money?
No.
You didn't introduce any evidence any more than anybody seems to have done as to what asked that question clean. Anybody in the commercial lending market would have been the fee.
That's right. The evidential burden wasn't on Samsung and Saipem. It was on the plan companies to satisfy the court as to the appropriateness. But we do have evidence in this case about value. I've just taken the court through it. That you have the value of this equity on day one, which is the plan company's own evidence. What other evidence are we going to put in? We didn't challenge that. We accept we're stuck with those numbers. That's what the evidence says. And you have the amount that's going in. So we know the two numbers. And we say the delta between them is so huge that this plan is unfair. And the case is as simple as that. It's been, I appreciate it's been 2.5 days, but that is the case. These plans ought not to be sanctioned.
Right. Anything else? Nope. Right. Well, thank you all very much. Can I a little bit of housekeeping? Obviously, we're not going to deliver an extempore judgment. We've got quite a lot to think about. Can I first of all ask, can you provide these notes in the final sort of agreed form as quickly as you can, and can you provide them in Word as well as PDF, or indeed any of the notes that have been provided to us? Thanks to you. Can I, as well as those who've addressed us from the front row, can I thank the juniors who've undoubtedly put a lot of work into the case, together with everybody who's behind you, who's been responsible for putting together some brilliant bundles and on-screen materials at very least. So thank you all very much for that under time pressure. I think I also need to thank the transcript writers who've stuck with us. We'll obviously give thought to our judgment as quickly as we can. We understand this has been brought on with expedition, but obviously we do need to have some time to think and produce a judgment. When we do produce it, we will be delivering it in the usual way in draft. We have a list of the people to whom it should be supplied, which has been provided, I think, to my clerk. If there's anybody else who needs to see it when it comes out in draft, please can their names be provided to us ahead of delivery of any draft judgment. Those who are here regularly know that when the draft judgment comes out, it's an opportunity for you to correct our grammar, spelling, and any obvious mistakes, but not to re-argue the case. And it comes with an embargo at the top of it, which means what it says and any breach of the embargo. And that includes use other than for the purposes of providing correction and taking legal advice. So any other use for the purposes of publicity or anything else is forbidden and would be taken seriously if it's breached. I think that is all I need to say. So thank you very much for those who have stuck with us, and we will now reserve our judgment.